offends someone, if it is vulgar, or if it indicates gang activity. They have freedom of speech, protected by the First Amendment of the Constitution. However, if a high school student walks down the hallway of his school and says the same exact thing, or wears the same thing, the school has the right to suspend the student. While it is true that students do not surrender their rights to free speech when they enter a school, their rights are much more limited than an adult outside of school. Take, for example, the case of 13-year-old Toni K. Scott of Napa, California. On the first day of school in 2005, Ms. Scott was escorted by a police officer to her school principal's office. Why? Because she was wearing a denim skirt. Jeans violated Redwood Middle School dress code, along with piercings, pins, clothes with the logos of sports teams, patterns or stripes of any kind, and any clothing containing the color red. Schools across the country have taken to extreme dress codes, even if it means doing something like sending home a student who is wearing a red American Cancer Society pin, which the same Napa, California school did in 2005. Students argue that they should be allowed to express themselves in their clothing and that the dress codes have gone way too far. However, it is not only dress codes that inhibit students' rights to free speech. If a student says anything that causes a disruption or offends any other student or faculty member, the school has the right to suspend the student, even on occasion if the incident takes place off of school grounds. In 2005, Justin Layshock of Western Pennsylvania was suspended for creating a fake MySpace page mocking his school principal, even though the page was created off of school grounds. Another off-campus case is the 2002 Supreme Court ruling in Morse versus Frederick, which gave a principal in Alaska the right to suspend a student for holding a banner promoting drug use, even though the student was on a public sidewalk that was off of school grounds. Schools can suspend students for up to 9 days without a written statement of the rules broken, without a hearing from an unbiased faculty member, without the involvement of witnesses, and without the option to be represented by an attorney. What this means is that students can be suspended by their school for a free speech issue without their side being fairly represented. In 2001, James Levine of Washington State wrote a poem entitled Last Words about a school shooting. He gave it to his English teacher to revise, although the poem was not part of schoolwork. The teacher gave the poem to the principal, saying that the poem was violent and that Levine might pose a danger to himself or others. Levine was expelled 3 days later in what the school called an emergency expulsion. Levine sued, arguing that poetry was expression and was protected under the First Amendment. However, the court ruled against him, saying, quote, "We review, however, with deference, schools' decisions in connection with the safety of their school, even when freedom of speech is involved," said Judge Raymond C. Fisher. What this means is that schools can take action to keep their school safe, even if it means taking away a student's rights to free speech. These student cases are evidence that teens do have rights concerning the First Amendment, but that these rights are limited and can be overpowered by the rights of others. Schools and parents hold many rights that can squelch teen free speech and expression. The Constitution declares that the government of the United States shall not make a law that abridges the freedom of speech. But if there are American citizens who cannot speak freely, lest they be banned from their school, then clearly freedom of speech is abridged, and thus the Constitution, the basis of the American law system, does not fully protect teenagers. Thank you.